Thank you, Professor Marendra. I hope I'm audible.
Yes, you are.
Yes, very well. It's indeed a matter of great pleasure for me to be here today at this annual INSA meet and speak on such an pertinent topic, cyber law and cyber crimes, which is, obviously reaching a huge, paradigm shift, especially during the COVID times. I do intend taking you through, the current spectrum of what are the current laws and the legal framework we have in terms of cyberspace law today, not just in India, but I will also like to touch on a couple of recent trends and developments abroad. Now, as we all understand, especially during COVID, cybersecurity has been, at the helm of affairs, and the basic threats to cyber, in the cyber domain, to people, to property, to national secrets, or otherwise, has immediately, assumed great importance because a lot of online crime has risen during the last few months. And having said that, the if you look at the statistics, almost 85% crime rate has increased in the cyberspace arena as per the MHA figures also. And 44,000 or more, cyber crimes were there in year 2019. And that was, almost doubled from what was seen in 2018. And I'm sure with the current rise, I think it's almost threefold the rise during the last, 2020. Now, with this sort of increase, when we look at the kind of crimes which have percolated around this time, fraud is number one. Fraud specifically to do with corporate frauds and either arising out of phishing attacks or ransomware or otherwise. It is mainly to have unlawfully, illegally gain financially. Now that could be done through various modus operandi, or the method of committing crimes could be use of mobile or could be internet. However, Trojans or other I would say softwares or onion routing to hide their real identity are often used by cyber criminals to conduct commit such crimes. Now, this, that's not the only, worry, because right now 60% of our crimes in India, cyber crime space, is by, virtue of these financial crimes is the main focus or the agenda. The others being, defamation is number one also, and number two, blackmail. To with women and children, harassment, online harassment to them has risen in the last few years in India. Now, kinds of cybercrimes, if we try to segregate them, they could be crimes against nation, for example, cyber terrorism. We have seen the how critical infrastructure of a country, maybe a power grid or otherwise, can have be separately attacked by a cyber criminal or a terrorist racket and can create havoc, in terms of creating havoc in the affecting people at large, masses, in terms of masses. Now, if you see the kind of scenario in that regard, that will amount to cyber terrorism, and the punishments given under our current IT Act are almost to life imprisonment. That is the extent to which the deterrence is there in terms of the Information Technology Act we have today. Then comes the other kinds of offenses like crime against property, where data, for example, or a computer system or a server could be hacked. And then comes the say humiliation or harassment or a trolling done to a particular individual, defamation. Those kind of offenses, crimes are also there. So if you see the kind of paradigm, there is a huge, I would say, spectrum of where one can create, kind of, I would say, effect in terms of cyber crime can have on people, on property, on nation at large. Therefore, the relevance of cybersecurity in today's times is quite apt and it's quite imminent, given the fact that a lot of crimes are percolating through cyberspace. Now, with this, I would like to just touch on a few cases. For example, when we talk about man-in-the-middle attack or a phishing attack, there have been a number of cases where phishing has been particularly used. If, for example, if there was a buyer X in a country and a seller Y, in another country, and there could be an insider maybe, or otherwise somebody who knows the connected email IDs which are being used to conduct a transaction. And if that is spoofed, a new identity is created by making a slight change in the email ID. And to create confusion between the two parties, the hacker would actually create this ID and be a middle person where he would pretend to be, say, the seller and ask for monies to be paid into a particular account, which would be siphoning off the monies. So these are quite rampant, these kind of cases. And in large number of cases, a fake identity which is created by using those tools or software may not even be detected. Sometimes a person may be, he's sitting in a third country and using sophisticated tools like onion routing or Tor, by which you're not able to detect, if there has been a crime or not, and from where. So that is the challenge which law enforcement authorities today face. And having trained, law enforcement authorities in India for past 2 decades, I can safely say that even though we are imparting trainings to CBI or to the National Judicial Academy, police academies, yet because the law keeps changing, the kind of techniques of committing crimes keep changing, and with the dynamism of the same, law has to catch up pace with technology and the kind of modus operandi which criminals are using today. So in one of the cases which I dealt with, interestingly, the client was based out of US, and a website was to be created by a vendor in US itself. This vendor had a back office in India. And when the website was created, Indian back office was used to create this website. And after handover of the same, the IP which was created, the intellectual property, this back office hacked into the servers of this, end client, and took away the information which was actually built for them, including the source code. Now, with that kind of a scenario, the legal implications are many. So, as a result of which, what we did was file a criminal complaint and approach the court, the local court. In this was a Gurgaon case. So, in Gurgaon court, and there we took up the local commissioner, orders for appointment of an officer of the court who would go and confiscate this server from where this has happened, or this particular network which was used, and the systems. And that was done with the court orders. And injunction was obtained, restraining orders that they cannot misuse this information. And they were confiscated and brought to the court, basically put in the court custody. So these kind of cases involve a lot of, I would say, understanding of the law and what is the right legal recourse in such a scenario. And in many cases, specifically if it is a cross-border case, the MLAT system which we have in India, the Mutual Legal Assistance Treaty system, there is a lot of time lag between which a law enforcement authority gets electronic evidence from a country abroad. And that is also one of the key challenges, to enforcing the cyber law in India. Now, with this sort of I would say scenario, it is important now for me to just very briefly explain you what is the current law legal framework in India for the same. Now, when we talk about these cases, the IT Act, which is the Information Technology Act 2000, it is as old as 20 years now, this legislation, and has been changed a couple of years ago in 2008 and 9 also. Certain amendments have occurred. Now, by and large, the offenses which are like hacking, for instance, have been dealt with in it by giving about 3 years of punishment and fine or more. This is the kind of punishment that is provided under the Act, Section 66 of the Act. 67 talks about any kind of transmission of, say, sexually explicit or other content which is illegal, if it is transmitted, That is a punishable offense. 67A again talks about the same. Sending or publishing any kind of obscene material is illegal as per the law of the land. And again, punishment of up to 5 years is given in the same, in that provision. Section 66E prohibits invasion of privacy, creation of any kind of MMSs or other, videos. And corporate liabilities are actually given under 43A, Section 43A, whereby they are supposed to compensate anybody who has suffered on account of their negligence or their not following the proper procedures to protect their personal sensitive information. So that is something which falls under compensation. And if they are at fault criminally, they could also be criminally liable. So with this, basic provisions, there are also provisions for protecting children. For example, 67B of the IT Act, which prohibits child pornography and any kind of publication or creation of the same. Also, there is we have sections on prohibiting cyber terrorism, which I mentioned, 66F of the IT Act, which has almost a punishment of life imprisonment. And that's very deterrent as well. And if we look at identity theft, a lot of people create fake profiles on the web, whether it's social media or otherwise. Now, that's again a punishable offense by up to 3 years of imprisonment, fine or more. So with this sort of a legal framework, this is the main legislation, the special law. But apart from that, we have IPC. In IPC, we have other sections which are also sometimes used alongside the IT Act, depending on the circumstances of the case. And in some cases like IP thefts, Copyright Act could be invoked. If it's a narcotics case, so NDPS Act would be invoked. Depends on the what exactly is the customized, I would say, peculiar facts of every case that we would use any particular law or legislation. Now, in many cases, for example, the what is to be seen is what is the remedy after all. Now, supposing there's a data theft, a lot of times I've dealt with cases where employees, ex-employees have stolen data from their organizations, whether it is by email or otherwise, and that digital evidence is used in a court of law. And we use that digital evidence to prove that there has been a theft, or if it is for the employee to say that he has not stolen, if he has actually not stolen and he had actually just forwarded the same for his work purposes. Now, with this sort of a framework and this sort of a scenario, now when we talk about employee frauds, in courts these cases go and digital evidence is considered admissible. And there is a section 65B of the Evidence Act, which requires an affidavit to be given by the court in the court to say that whatever emails, for example, have been produced or the electronic evidence has been produced from the computer that is being like storing this information on a day-to-day routine course and is not malfunctioned during the relevant time. And the CTO, the chief technology officer of the company, normally gives that undertaking, and that is admissible. That makes the digital evidence admissible, and based on that the court decides the matter. So in number of cases, we have to see what is the remedy that we want. Is it compensation that we seek? Is it restraining orders that this IP, if it has been disclosed or leaked, should not be misused by the employee, for example, or a competitor who has got hold of that information has to be stopped from you misusing it and give back this property. So this is important. We have to see the remedy. What exactly is the main relief that we are seeking? Also, in many cases of IP, the delivery back of the goods which are taken. Like, for example, if it's electronic data, this is maybe saved in a hard disk or otherwise, should be handed back to the company. So in that scenario, that is also sought. Damages are sought. So it depends on the main situation, what exactly is being asked in that particular scenario. Or if it's a information which is defamatory, that needs to be taken down. So a takedown order has to be taken from the court, where the court will basically direct that information has to be taken down from the website or a particular page which is maintained by a particular person. Now, with this, the kind of courts which are there today, obviously, when we look at criminal law, we have a criminal justice system where criminal courts are in function, and then there are civil courts. For example, if we need a restraining order, we go to the high court. We go for original site jurisdiction, and if compensation is needed, for example, a data theft case, compensation is needed, we also go to adjudicating authority, in order to get that compensation. Having said that, now when we talk about the current scenario, how effectively are we able to tackle these problems? I do agree that to a lot of extent, at this present moment, with the trainings and with the investigation authorities which are currently being trained, we are able to, track a lot of cases. However, there is less reporting. There is less reporting because of the fear of, whether we'll get justice or this whole recourse, how long will this will take, because there are backlog of cases, and we all know that we are well seized with this issue, and therefore the need to create more I would say not only laws for newer issues like fake news or otherwise, but we also need more courts in order to make this whole process more effective. And there is definitely need for more structured trainings, and that's what needs to be highlighted, that we need new laws to protect data and privacy. And that's why PDP bill is being debated. Currently the Justice Puttaswamy case has brought Justice Sri Krishna committee has given this recommendations, and the bill is being debated. And I was happy to see that a lot is being done in that area to safeguard personal information of people and of companies also. I've now also realized that there is a new law which is going to be created also for non-personal information, which will go a long way in protecting organizations' data as well. So with this, cybersecurity is also is being debated a lot. The national cybersecurity policy currently is being framed in the country, apart from the PDP bill, which is being debated. The e-filing process has already been established in many courts, and I was happy to be a part of that as well, where we worked on, every court, like a district court, 18,000 more courts can now have a software by which anybody can file a legal case through online means, which is a huge tool to give to every citizen of India. And if the courts have adopted that, this can actually play a very important role, and a pivotal role even in rural India. If anybody can actually just access this software and use it to file any case, which is needed. And then we have new rules which we are debating on for cyber warfare. Because of artificial intelligence, a lot of new, would say, methods of or deployment of these tools, artificial intelligence-based tools, is happening even in the cyber warfare arena. There we were looking at, with VIF, there was a report which was made where we were looking at how we can regulate this space, because there is a dearth of law at this point on this issue as well. And we need to structure, what should be the policy framework for India when it comes to cyber warfare, and how international cooperation can be also, meted out in terms of getting the full cooperation from foreign authorities to track this kind of offenses and to track down who's the offender behind it. Technically, it is possible in many cases where specifically, the other cooperation agency cooperates in that regard with Interpol or otherwise, and we are able to get extradition, for example, of the offender into India. I know it's not so simple, because the process is long and it could take about 6 months or more. And this we have seen these things happen. But there is technology coming to aid the law enforcement process as well. Specifically with DNA photo hash mechanism, we are able to stop duplication of content with using these tools. This social media is able to track what are these photographs which are to be being duplicated, that can be stopped from duplication on the net. And facial recognition systems are being deployed today. So newer technologies can not only pose challenges to us, but also give us solutions to these problems which are emanating through technology itself. And legal field, we particularly get seized with this idea of technology changing so fast and trying to adapt our existing law or create new laws. For example, for areas like fake news, we were working on it with the Ministry of Home Affairs on what policy measures really need to be put in place to control this space. With the Ministry of Women and Child Affairs, I'm working on the kind of policies and the kind of measures we can deploy at this in this in our India specific context to protect our women and children. Whether we need to impart trainings right from primary or secondary level to them, so that they can get more equipped with cyber safety etiquettes and practices. And especially during COVID times, the need for the same is heightened because of homeschooling. Those are aspects which are really not been so important, maybe not or not given that much importance earlier, but now have become imminent in today's times, that we need to take action on those quarters as well. Then comes social media liability. Are social media platforms really liable at all? Should we say that they are liable at all? Under Section 79 of our IT Act, they are under an obligation to actually take down information, remove information, which once they are informed, if there is a particular information which is obscene, or for example, if it's illegal, or a hate speech, something which is a racist remark, that needs to be removed, because it can create again public disorder and spoil the peace of the community. So in that regard, they have to remove those kind of information within 36 hours of their receiving a notice. If they don't do that, they are responsible and they could be made liable for the same. And that is what the social media liability is. And even at the Supreme Court, we are looking at areas like, can we stop duplication of child pornographic images from the web? How safe is it for the children? It isn't. We are aware of this, and that's why we are trying to tackle these issues. In a case like Kailash Vaswani's case, we were discussing these issues, and even the Supreme Court has given directions to block child pornographic and other materials from the web. And the technical I would say the service providers, they are working on it with technological tools to actually be able to achieve the goal, but it's not simple. It's just not simple. And therefore, our law is also evolving with times. Earlier, the orders of the court used to be ban a website, stop a website, but that doesn't happen. If you banning the entire website, unless the whole of it is illegal, that will not be a logical thing to do, and not the right thing to do as well. So what the courts have now started doing is block a particular page if that is defamatory, or block a particular content on a site if that is alone defamatory. So that is the practice today. And with the kind of piracy, even of music or videos or movies today, dynamic injunctions have come into being, which means that if the same movie is replicated or pirated and published in several platforms on the web with a one single order of the court, you can actually block that particular video or a particular movie or a trailer or a song from viewing throughout the web. That's possible after the court recognizes there is a hash value or there is a particular value to that particular content. And if the same content is there at every place, then the person who's maybe a producer doesn't have to go to the court each time to remove every link, but he will just inform the particular website provider that this is a link which is illegal, and by virtue of this court of order, this order, which is a dynamic injunction, you are under an obligation to remove the same. And that can be achieved. So this way we are trying to work out our legal framework or legal concepts in such a manner that we are adapting our judgments, our way of evaluating the technological and challenges and the new legal issues which emerge on the cyberspace with the current legal framework that we have. We are trying to apply the same with a slight adaptation or finding some new solutions in one of the cases which I dealt with, one lady was, defamed on 17, 18 websites, and these websites were all foreign websites. So with that, we checked up these registry service providers and who is the registrar of that website. And by sending them legal notices, those were removed in, again, 36 hours of time. So even without approaching the court, it was possible to do that. But it may not happen in every case. So depending on the situation, first we send them a legal notice. If this works, fair enough. If it doesn't work, then we sue the particular parties involved who have not acted as per the law. So with this sort of a we are able to get results for the clients. So the idea is to understand the problem, and then we apply the technological challenge, we understand that, and then we apply the law which is currently subsisting in the country, and we try to adapt the same, or we try to create some new laws. Definitely, as we stand today, in the times that we stand today, I think our greatest challenges will be to address things like fake news, things like trolling. We have seen a huge trend, even with the Me Too revolution. How much internet, what role it plays in today's times, and how it can affect the lives of everybody. And it is a challenge, definitely. So using technology for the right means, and using the law to protect the rights of people is today, it's a huge challenge because of the dynamic technology itself. And we, from the point of view of the legal enforcement and lawyers, expressly we are working on the enforcement challenges. We are working to build, for example, rules to make digital evidence admissible in a court of law. We are working on trainings, public awareness, and also advocating the creation of new laws and new courts to make our justice delivery system more robust, more I would say effective in terms of getting redressal for people who it's trying to protect. I think with this, I'd like to conclude by saying that in a line that the regulatory framework we have today is always work in progress, because there's lots to be done with the changing technologies today. We are working on this constantly, both at the from the point of view of creation of laws and the enforcement challenges, and the new technological, I would say, issues which are emerging are helping in the evolution of law itself to protect the people of the country, and work towards better international cooperation in combating cybercrime, which is not just a domestic issue, but it's a global issue and a global phenomena today. Thank you.
Yeah, thanks a lot, Dr. Seth, for educating us about various cyber laws that exist today and what are the deliberations happening, covering other aspects that are at present not there. Also, the challenges that are there to define this law, because there is always this trade-off between the protecting one individual's rights versus allowing freedom of expression to another individual. So it's where one has to treat very carefully, and the problem becomes more difficult with the social media and such platforms. So that brings us to a conclusion to this session of talks. If we have some time, we can answer a few questions. I see in the chat box a couple of them.
We can do for 5 minutes, 5-7 minutes. We can do.
We have 5 minutes. So there is one question for Dr. Seth, that in e-filing of cases, are the court servers secured enough so that evidence is not tampered with or doesn't leak from there?
Yes, absolutely. There's no doubt about that. There is a whole team of technology experts who work on it, and NIC, which is also the main body which worked on the e-filing rules with us. The e-filing technology, it's all sound, it's all encryption based, and we are at the moment also working on having new laws for digital evidence, for taking digital evidence. For example, if you file a particular drive or a pen drive or other I would say gadgets, or maybe a mobile is put in the custody of the court, would that be remaining there, or would it be just a hash value and a soft copy of the same created? So working on that whole system, it's an ecosystem which will have to work, because right from the time of production to verification, and then retrieval, and then destruction, everything has to be looked into. And that's something, technologically, without deploying these measures, it will not happen. It's foolproof encryption that will be used, as a zero tolerance level. Absolutely.
Thank you. One question which also Dr. Shukla has already answered on the chat box, but still it's important to highlight this point that awareness about pitfalls of the digital domain. It's a huge challenge because from children to senior citizens, everybody is these days making use of the cyber or digital platforms, doing a lot of activities there. Even these days, purchases are happening through. There is always a serious risk of financial misappropriation, which one does hear about these cases. Apart from this, traditional emails that come from Nigeria and other places offering very large sums of money, but that's probably has become a little stale. But the new types of enticements are always coming in. People hack into the machines, your device, encrypt all the data, as Sandeep said, and then you have to pay in bitcoins to get them back. All of this requires proper education of citizens of the country, what they should be careful about when they are in the digital space. And there's no easy solution except to continuously hammer home the point that just like traffic, the basic necessary types of behavior that everybody needs to be educated about is continuously and
yes,
told about.
And I'd like to share something that I'm very glad about. It's having trained the law enforcement officers for a long time, I realized that this information is so important for the younger children today, and even academicians and teachers, that I set up an NGO called FIRE, where we're doing a lot of trainings, and we've trained almost 2-3 lakhs of students across India. And that's just a not-for-profit initiative, but it has done really well, especially during COVID times, where we close to about 50 sessions have been delivered just for free, to children who are being updated on what are the best practices when they're using computers to do their schooling today. So that's something which is interesting to also share with you today. And I also want to share one more thing, that I was reading up and I was writing about artificial intelligence when I realized the need for data ethics in data science. Because when data miners or other people who are working on new technologies like AI, and I've seen this built, I've seen robots being built, because I'm also a mentor to the Hatron, which is in Haryana, where they're making drones and making AI based devices. The need for data ethics really needs to be underlined today, and we have to have a code. We don't have, unfortunately, at this point, a complete codified body on this, but it will be good to have maybe INSA or IIT work on this, and with of course legal expertise involved to codify them. That will be a huge takeaway if we can do something on this end.
I think I will I wondered when you mentioned about education, Dr. Agarwal, and we had talked earlier also, and what was mentioned by Dr. Garnika said, can we think in terms of having a booklet which INSA could publish outlining this, and this can be updated on various aspects which were talked about in this one? I think this is very important. We will like to, I will make sure that we send the videos, this video to all institutions, but there are many people out there. And I think there must be a mechanism that we should keep training them. We are only training the trained people or educated people there, but cyber world is used by many which are not skilled and trained. So in a country of digital divide, how do you handle them? So kindly think about it. And if you wished, if you could bring out a simplified version of your talks, I think it will be a very useful document for INSA to bring it out as an open access document.
Certainly.
I know you are all very busy people doing more important things, but probably this also is an important thing that we educate through INSA. And I think it will be worthwhile and an effort. About 30, 40, 50 pages of material in simple language, which was told by all of you. And I once again, please think about it. I'll come back to you. And
Can
you
I
know,
mention something?
Yes, please.
Maharashtra Cyber Cell has a wonderful booklet with cartoons. It's about 16 pages, large A4 size pages. It's a booklet they give out for free. It has very colorful cartoons to actually tell people about phishing and OTP hack and SIM card hack and all that stuff. So I think all other states should do something like this.
I think why I'm saying INSA being a pan-Indian system, INSA could do a very good job of it with the actually professionals which are at the highest level. So, and with Dr. Seth's help, we can really bring out a small booklet.
Certainly, I completely endorse your view, and I would be happy to contribute. I've written also a book for NCPCR, which is the National Protection of Children, this commission, and also there have been books on protection of children on internet or computers, internet, new technology laws, and various other publications I've authored on for various audience. It really depends on who we are targeting. If it's also highlighted as to who you want to send this out to, I think that will help, because the language has to be accordingly built.
Yes.
The content.
Yes.
Yeah.
Well, I'm